clearly on here, the court finds that the plaintiff, Shigret Urania Doss, signed the stipulation of the parties pursuant to the mediation conference. Yes, I did. The court orders that pursuant to the settlement agreement included as A to the defendant's motion to enforce, I shall, meaning I must sign this. And by the way, we all know that as a matter of law, as long as I understand what the judge says, I can't just disregard it. So she forced me to sign this through coercion that included parties that we never talked about this stuff about. None of you all made an appearance at the mediation conference. In fact, Stephen Chauvinik, who was an attorney for the United States government, didn't even make sign the certification of attendance and authority. And he shows up and doesn't even tell me who he is. I think it's pretty odd that, by the way, for you all who don't know, you attorneys have read everything I've filed, and I'm sure you follow me. Title 18, United States Code, Section 208 is a crime. And court reporter, if I'm flowing a little bit too quickly, just slow me down and I'll slow down. I forgot about you. But Title 18, United States Code, Section 208 is a federal crime. You all colluded to allow Austin Road Basketball Professional Association and Dr. John Shim, and I don't want to say the United States government, we're going to find out, to commit criminal activity. You do have an obligation to tell me that Dr. Shim works for the VA. And the fact that you said that is disrespectful to the people who may actually now be in more harm because of the events that occurred on Saturday. Only 6% of us put on a uniform. And to have somebody tell me that a veteran who was willing to put his life on the line with other veterans does not have a right to know that their doctor is compromised, that's insulting. But let's get right here. Should the plaintiff fail to sign the release within 10 days of this order, the release shall be enforceable as if the plaintiff executed the release. And we'll go right back here. And there we go where Judge Emily Ann Peacock says, okay, so Mr. Doss, you're not going to argue with Mr. Rowe during my hearing. Do you understand? That's disrespectful. Secondarily, so I'm entering an order that enforces the terms of the signed mediation settlement agreement. That doesn't exist. And if it exists, I need, whether it's Tabitha Blackwell, Michael Rowe, Scott Gavin, Judge Huey, or Mr. Wymuller to produce the mediation settlement agreement, not the stipulation of the parties. And we're not going to change the title. Now, let's continue on. Do I have to pull up I'm going to do this for the sake of edification about the certification of attendance and authority. But that's Rule 1.720E. And while I'm pulling that up for Florida, I wanted to do something else as well. This is my release. Can you all see the release on the screen? This is what Judge Peacock ordered me to sign. Yes. Can you all see the release?
Yes. Yes, sir.
Okay, I appreciate that.
Yes.
Let's all say it with our chest. Listen, at the bottom of this release, first of all, I want you all to read this part here. This is what Judge Peacock ordered me to sign. I hereby declare that the terms of this settlement release have been completely read and are fully understood and voluntarily accepted. To tell a black man in any era that you're going to do what I tell you to do, and I'm going to mischaracterize it as voluntarily, is disrespectful. I know what I'm looking at, and I mean every word that I put in that writ of motion to disqualify you, Judge Huey. This is not new. I went to elementary school on a plantation in Biloxi. So let's get back down to here. I want somebody to tell me that you do not clearly see where Shigret Doss signed that under duress, and I have a witness who was with me when I did it. We're playing this game with the entire judiciary, and you all are supposed to be legal professionals. It's real simple. We could have easily resolved this matter. But what I'm not going to let you do is take advantage of veterans, which Michael Rowe's associate said, we had other cases unrelated to Mr. Doss where plaintiffs treated the VA, see Dr. Shim, and nobody raised an issue. That is patently against the law. And on behalf of every person who put on that uniform, I am obligated to stand here on their behalf and fight for it. And I'm going to keep banging the drum until somebody with a lot more authority than around here finds out what you did. And I will be happy when I see some people in handcuffs. And I'm not going to stop until I see it. That is an abuse of authority. She operated outside of her authority because I didn't sue all these other entities. And why would Shigret Doss, who's demonstrated intelligence, release the nation's largest automobile insurer for anything that could happen in the future? That would foreclose my action, what I'm sure you all know, against Kelly Johnson, where Morgan & Morgan is representing me. The bottom line is, show me the mediation settlement agreement. I object to the characterizations. I know I have an idea what you're probably going to do as far as the ruling, but I just wanted to put these things in the record. Furthermore, I want to show you all something here. Since we all know that 1.720E states quite clearly, requires that the parties file a certification of authority 10 days prior to appearing at a mediation conference, identifying the person or persons who will be attending the mediation conference as a party representative or as an insurance carrier representative, and confirming that those persons had the authority required to by the rule. Now, I don't even know that Michael Rowe ever had the authority to represent the interest of other parties. And if he does, Judge Huey, if you let the case go, but I'll amend the complaint, which I think is sufficient because I'm entitled to liberal construction. I can amend the complaint, but if we get through this discovery and they stop tap dancing around those requests for admissions and the interrogatories, I'm quite sure we're going to find out quite a bit. The bottom line is the prior case was never litigated on the merits, so res judicata does not apply. It was litigated. It was dismissed with prejudice, Judge Huey, and I'm going to give you a mulligan because they lied to you and you took their word. But the facts in the documents show Shigret Doss never signed a mediation settlement agreement. The facts in the document show Judge Peacock ordered me to go sign that document. The facts in the case show that the only thing that I would have settled is that litigation, 2018 Charlie Alpha 3553. Not this other stuff that you all have been, I can't even believe attorneys would do this kind of stuff. Now I've had to spend a lot of research. No, I'm not finished. I want to close with this. I object to the totality of, I want all their motions to dismiss, denied. Furthermore, I believe I'm eligible to file for summary judgment. I'll look into that because they didn't answer the allegations in the complaint. They talked about everything else but the allegations and the truthfulness of the allegations, which the four corners must be construed to be true. None of these parties address the allegations in the complaint. And I'll rest with that and wait for your decision.